Item 7.3, direct staff in response to pending open records request based on statutory authority and discretion provided to municipal organizations as contained within the Kansas Open Records Act.
I'm going to look towards Mr. Bankston and Mr. Gage.
I'll start since I had to put my name on this thing. You'll probably find this has the least amount of information of about any commission report you've ever received, so I apologize for that. But there are some pieces of information, correspondence, as you know, that are placed in front of you for action. Typically on open records type requests, staff will deal with those, but these have been elevated to your level. And I purposely stayed away from anything that would in any way identify them, to be ultra conservative as to not, by my actions in this report, automatically cause the pieces of correspondence to be released if in fact, in whole or in part, if in fact you would not deserve or desire for that to happen. So I didn't make reference to who they're to or from, the dates or anything like that, and that's the reason for that. And that's with special consideration. And as I mentioned, under the Kansas Open Record Act, as you know, that if certain records are addressed, either it could be by me in this form or even by you in your conversation, which makes this difficult and awkward, I know. But you could, the result of your conversation could be the default release of a record without consideration of the body. So we'll ask for Greg's guidance on this, but I will say that at this point we can refer to the correspondences. I'll call them letters number 1, number 4, and number 5. So that, I think that rings a bell, and I think you know what those mean. And so with that, I'll defer to legal counsel and assisting you with how you might go about having a conversation about what you would like to do with those without by default releasing them by the conversation versus a vote.
Well, I think as the city manager pointed out, for purposes of your consideration, I think referring to the correspondence by the numbers with which I believe you have reason to be familiar with them might be the best way to handle that. And I don't know if that is sufficient as far as the development of a motion on anyone's part, or if not, we can discuss further how that might be approached.
We've had the recommendation of outside counsel on these items, is that right?
Yes, that's to the extent that might be helpful. We had a situation where my role had to be minimized from the standpoint of the unique circumstance of one of the pending open records requests having been originated at that time by a sitting commissioner in Commissioner Blanchard. And the other aspect that the correspondence, two of the pieces of correspondence involved were correspondence that I had opined on in relation to their release in a redacted form, I suppose, 3.5 years ago now. So between the request having been made by a commissioner and my having previously opined, we look to special counsel to assist in analyzing that correspondence under current circumstances, and we have the benefit of that recommendation.
Well, we could just hazard a guess that we're going to accept our counsel's recommendation. Would that facilitate a motion?
Yes, and if that were the case, I'm sorry, Commissioner.
I just had a couple questions whenever you're done with your train of thought.
Well, I was just going to say that based upon that recommendation, I believe that would potentially lead to a motion that would anticipate the release of what had been identified as correspondence number 1 and number 4, as well as the release of what had been identified as correspondence number 5, however, in the redacted form that had been indicated was appropriate under the Open Records Act.
question, well, maybe questions and a couple comments. Mr. Bankston, you did a great job sending us to Anna Christlick. I don't know if I'm pronouncing her last name right. It's Stinson Leonard. Will her analysis and will her letter, is that subject to open records?
No, in that, well, let me put that this way. That particular document in its current status is a privileged communication from her to the city. I believe it's directed specifically to the city manager, but for your utilization. And that would be, that is a confidential communication at this point in time. It is, in that I say confidential, it is a privileged communication at this point in time. That privilege is held by the governing body, and whether that privilege is sustained or waived is at the discretion of the governing body.
Gotcha. If we're taking action based on her analysis, does that change anything? I mean, if we're going to follow her recommendations in terms of opening letters number 1 and 4 and redacting parts of 5, I was just curious. I didn't know if that would, the fact that we're relying on her analysis would force us to open that letter.
No.
Okay.
Not that aspect in and of itself, I don't believe.
Okay. What was the date on her letter? I'm sorry, I don't know if I thought you might have it handy there.
You're putting me in the position of potentially citing to the correspondence in a way
I'm
that could
sorry.
potentially.
I'm sorry.
I do not wish to affect
No.
its status.
My point was, and I should have asked it differently because I didn't mean to ask you to cite
No, I
the letter
understand.
by name. But this has been a long process that you alluded to, and we've had the letter and had an executive session on it last week and did not take action. So I was just hoping that maybe you could speak to the delay between getting the letter, having the executive session, and then taking action today. Because the initial request, I think, was like November 18th for the open records
Right.
request. And normally in an easy, straightforward one, that's what, a 3-day turnaround?
That is the statutory threshold, yes.
Right.
I'm not sure I don't think I'm grasping your question.
Okay.
I gather that I may not be
Okay, I guess
grasping
my
your
question is, why the lengthy delay? You alluded to it earlier in terms of the delay between November 18th and whenever the letter was, the analysis was received, and why there was a delay between when the letter was received, our discussion of it last week, and then postponing action until this week. Why was our timeline so long in terms of receipt of the letter between taking the action tonight?
My sense of the matter, and maybe Mr. Gage wishes to comment on that, was that it was a matter of the timing of the opportunity to schedule, when your meeting schedule allowed for the executive session, and there was not opportunity at the end of that executive session last week because, well, there was no agenda item and no anticipated action, as I recall, which is what prompted it being set for action this evening. I mean, that's my...
And there were also some notifications to make, correct?
I'm going to be honest, I'm not going to speak to
Okay.
anything that deals with the contents of that letter.
Okay.
Because my whole point is not for our discussion to cause that to be disclosed without you taking action. If you take action, depending on what action you take, then I think at that point, full disclosure, if we wish to, we could do that because you'll take an action for that to be released. But absent that, I can't speak to that.
That's all I have.
Any other questions or discussion? Well, the chair's ready for a motion on this item.
I move to take the action so eloquently described by the city attorney. I hope I can repeat it. It'll be to, the proper term would be to release letters 1 and 4 in their unredacted state, and letter 5 in the redacted state.
Is there a second?
Second.
Any other?
Real quick, for clarification on the motion on the letter 5 in redacted state, that would be as recommended by legal counsel.
Yes.
Okay, thank you.
Any other questions or discussion? All those in favor, say aye.
Aye.
Any opposed? Development business, 8.1.